Hi everyone, again, my name is Danielle Troop.
And I'm Stephanie Orozco. We are both advocates with Mariposa County Victim Witness Services. Both of our caseloads include all crime types, and in our roles as advocates, we assist victims through each stage of the criminal justice process. We help enforce their rights as victims of crime and provide necessary resources and referrals.
Today we wanted to shake things up a little bit, so what we're going to be doing is we're going to be busting some common myths that we get as questions from people who contact our office. So let's get started. The first myth we're going to talk about is the district attorney works for me and is my own personal attorney.
That is false. The district attorney is for the people of the state of California, meaning they represent the people as a whole and not individuals. You could hire your own attorney if you choose. However, we are not able to provide you with any legal advice. A victim rights attorney would be able to assist you if you feel as if your rights as a victim have been violated. So the next myth is a victim has to press charges against a person in order for the case to move forward.
So in the state of California, victims do not have to press charges. The charges are brought forward by the district attorney's office, and the burden does not fall on the victim to pursue any charges. Next myth we're going to talk about says, I am the victim, and if I want to, I can drop the charges.
This is also false. Once formal charges have been filed by the district attorney's office, the victim does not have the authority to drop the charges. It becomes a crime against the state as a whole. Next myth, I have no say about the case even though I am the victim.
So that's completely not true. Under the Victim Bill of Rights Act, which is also known as Marcy's Law, you have certain rights afforded to you as victims of crime. To name a few off the top of my head, you have right to be treated with fairness and respect, right to protection from the defendant, right to confer with prosecution, the right to have notice of public proceedings and to be present at those proceedings, and also the right to appear at other court proceedings and express your views of what's going on. Those are just a few of the 17 victim rights that are afforded to you under Marcy's Law. So the next myth we're going to be talking about says, once I report a crime to law enforcement, I won't have to testify at all.
So this is not true. Once a crime is reported to law enforcement, the case may be forwarded to the district attorney's office for prosecution. The prosecutor assigned to the case will decide whether or not to file criminal charges. If charges are filed, you may need to testify at a hearing and/or at jury trial. Which takes us to our next myth. If I'm subpoenaed, I do not have to go to court.
This is not true. What a subpoena is it's a request to appear in court signed by a judge. Any person who receives a subpoena and does not comply with whatever it may say may be subject to criminal penalties such as fines, jail time, or both. So best thing to do is do whatever the subpoena says. Our next myth says, I will be alone on the witness stand.
So for specific crime types, Penal Code 868.5 allows for a support person to be seated next to the victim on the witness stand. The support person may not touch, interact, or react with the person providing testimony. And also per the Penal Code, another support person may also be present in the courtroom during the testimony. So next, all cases go to jury trial.
This is false. Many cases that come through the criminal justice system actually do not make it to jury trial. They will resolve beforehand in what's called a plea deal, which is the end result of plea negotiations made between the defendant's defense attorney and the prosecuting attorney. Our next myth says the criminal justice system has quick turnaround and my case won't take that long.
And while that is possible, the length and time it may take for the case to resolve varies. Each case is completely different and therefore will take a different amount of time. So it's just impossible to know just how long each case will take. Next, I am expected to know all legal terminology.
Our role as an advocate is to help victims navigate the criminal justice system and explain that difficult terminology. The criminal justice system kind of has its own vocabulary and it is not common knowledge at all, and we don't expect you or anyone to know that. And so we want to make sure that victims have a good understanding of court processes and procedures. So we'll be there at each step of the way to answer any questions and provide any information necessary. The next myth we wanted to say talks about victim services can only help me if charges are filed.
Not at all. We can assist any person that has been a victim of a crime to the best of our abilities, which often includes referring them to partnering agencies. Next, victim services can assist me with civil issues.
This is not true. We cannot provide any legal advice for civil issues, but we can make referrals to our self-help desk at the court, which may be able to assist you and answer any civil questions you may have. Another myth we're going to be talking about says victim services is completely confidential and they will not tell anyone what I've told them.
So this is not true. In our discussions with victims, the information shared is not completely confidential. There are times when we need to share the information in regards to immediate needs, certain legal obligations pursuant to Brady versus Maryland, or when the information could interfere with the progress of the case. So next myth, victim services can give me money.
So if a victim is eligible, we can assist them in filing for victim compensation through the California Victim Compensation Board, also known as CalVCB. It's an application process through the state of California, and it's available to victims of specific violent crimes. And that's something, like we said, run through the state of California. It's not something that we process right in our office, but we can definitely assist victims in filling them out and getting any documentation they need for the process. The next myth we want to talk about says restitution includes pain and suffering for the trauma I've endured.
So under Marcy's law, victims of crime have a right to restitution. Restitution does not include pain and suffering as a civil suit normally can. Restitution can be obtained if the defendant is convicted of a crime and there is true out-of-pocket loss. Next, I am having trouble sleeping, having nightmares with some anxiety and depression. This has nothing to do with my trauma, and I am just going crazy.
So you're definitely not going crazy. What we do know is that trauma impacts everyone differently and that these are common experiences for some victims of crime. Healing from trauma is not a quick process. So what we can say to people who are experiencing this is give yourself some time and obtain helpful resources. If you contact our office, we're more than willing to help you, as will your local Victim Witness Services office. Well, that concludes our common myth busting. Thanks for watching. Keep in mind, each case that works its way through the criminal justice system may have its own set of roadblocks, different potholes, or crazy detours. Our role as advocates is to help enforce your victim rights along each step of the way, no matter what may happen. If you have any questions, please contact our office or your local victim witness office.
Thank you.